Hello, and a warm welcome to the EDRM Global Webinar Channel. My name is Mary Mack. I'm the CEO and Chief Legal Technologist for EDRM. Today's webinar is a collaboration with EDRM trusted partner, eDiscovery Today, now in its 5th season. It's called The Most Important eDiscovery Case Law Decisions for July of 2025. And our faculty experts are Doug Austin, Tom O'Connor, the Honorable Judge Andrew Peck, and myself. We welcome your questions and feedback in the council. Questions will be answered both during and at the end of the webinar. And this webinar will be available for replay at your convenience for the next quarter, as are all of our EDRM webinars. And slides will be available after the webinar as well. Kaylee Wallstad, EDRM's Chief Strategy Officer, is here. Can you please tell us what resources are available today, Kaylee?
I'd love to, as long as you can hear me, Miss Mack.
I absolutely can.
Well, that's outstanding. We're loving On 24, and we hope you, our audience, are as well, with so many more ways to engage. If you check out your console to the right of your screen, you'll see the question mark icon. And if you click on it, this is where you can type in your questions for today's faculty, and we highly encourage you to do so and engage. Then the paperclip icon. If you click on that, it's for related content. And you will see today's resources carefully curated just for you. There's an On24 engagement tool descriptor, a link to subscribe to eDiscovery Today's blog and never miss a thing, and a link to learn more about the Honorable Judge Peck and how you can engage with him, a link to order your copy if you haven't already, for those who show up every month, Tom O'Connor's spicy book, eDiscovery for the Rest of Us. And it was just recently updated in a collaboration with EDRM's trusted partner, NextPoint. So it is definitely worth ordering. And then Tom O'Connor shared 2 links for us regarding litigation funding. And you'll see those 2 articles with links, and we hope those will be helpful to you. And then be sure to save your seat for next month's important eDiscovery case law decisions for August, on August 25th, now in its 5th season, as Mary said. We're very excited about that, by the way. And up next on EDRM's webinar channel next week, August 13th, chat data, the ugly discovery data source. Be sure to save your seat. And then speaker bios can be clicked and popped up to learn more about today's faculty. And just like Zoom, you'll see the smiley face emoji. And if you click it, there's many more reactions that you can click during the webinar, and we highly encourage you to engage with them. We're having a lot of fun with them on this platform. And if you click the Twitter bird, you can follow EDRM and eDiscovery Today on LinkedIn. Back to you, Mary.
Thanks, Kaylee. And we have as our faculty, of course, Doug Austin. Doug Austin is the editor of eDiscovery Today, a daily blog about eDiscovery, information governance, cybersecurity, data privacy, and artificial intelligence trends, best practices, and case law. Doug is an established eDiscovery thought leader with over 30 years experience providing eDiscovery best practices, legal technology consulting, and technical project management services to numerous commercial and government clients. Doug has published a daily blog since 2010, even while on vacation, and has written numerous articles and white papers, receiving the J.D. Super Reader's Choice Award as the top eDiscovery author and top cybersecurity author. Doug has presented at numerous webcasts, events, and conferences, including Legal Tech New York, Ilticon, Relativity Fest, University of Florida eDiscovery Conference, the Masters Conference, and many local and regional conferences. We also have the fabulous Tom O'Connor, the director of the Gulf Coast Legal Technology Center. Tom O is a nationally known consultant, speaker, and writer in the areas of computerized litigation support systems. Tom's consulting experience is primarily in complex litigation matters, where he's worked with firms of all sizes, including the plaintiffs in the BP litigation. He's also been appointed as a technical consultant by various federal and state courts dealing with large amounts of electronic evidence. And as Kaylee said, his most recent edition of his popular book, eDiscovery for the Rest of Us, is ready for download. Tom also hosts with Rocky Messing, the eDiscovery channel on YouTube. We also have the Honorable Judge Andrew Peck, who is a Band 1 Chambers ranked senior counsel at DLA Piper. Judge Peck served for 23 years as a United States Magistrate Judge for the Southern District of New York. And before his appointment to the bench, Judge Peck was in private practice for 17 years, focusing on commercial and entertainment litigation, including copyright and trademark matters with extensive trial experience. And at DLA, Judge Peck advises on copyright and trademark matters and also serves as a resource for the firm and its clients on litigation strategy and discovery issues from a judge's perspective. Judge Peck particularly advises on innovative and efficient solutions to the challenges of information management, both within and outside the litigation context, including cross-border discovery issues. He frequently speaks at conferences concerning eDiscovery issues, and since joining DLA Piper, Judge Peck has been retained to serve as special discovery counsel to clients and law firms and to submit expert reports on eDiscovery issues. And EDRM is grateful to all three gentlemen for their service on the EDRM Global Advisory Council, and we encourage you to catch Tom O and Doug Austin at ILTA. Over to you, Doug.
Thanks, Mary, and welcome everybody to our July case law webinar on the EDRM network. Yes, we know the calendar says August, but we're not done with July just yet. As always, we do have another 6 unique cases to discuss this month, and those cases address disputes related to improper boilerplate objections, confidentiality agreements applied to non-party recipients, sanctions for failing to preserve cockpit voice recorder and flight data recorder data, waiver of privilege by sharing documents with a third-party litigation funder, possession, custody, and control of a hyperlinked podcast file, and sanctions for discarding a laptop hard drive again. Of course, we do, as Mary and Kaylee mentioned, we do welcome questions, and we'll try to get to as many as we can. And we will send out a copy of the slides after the presentation, so look for that too. Of course, any ideas expressed by us here today are our own, not those of our organization's clients or partners. That's true even for those who won't have possession, custody, or control of this webinar recording. And before we get started with these cases, here's a quick note about the webinar format and sources of cases. This is the latest in a series of monthly webinars about case law, and the cases we discuss each month will be those covered on eDiscovery today. We provide links to each of the stories about the cases, which in turn have a link to the actual case ruling, where you can check out the full ruling itself. These case law rulings are available courtesy of Minerva 26, formerly known as eDiscovery Assistant, which is a great resource not only for case law, but also for federal and state rules, checklists and forms, and a glossary of legal and eDiscovery terms. Minerva 26 has over 43,000 lifetime federal and state case law rulings, and they add as many as several hundred cases a month. Minerva 26 is the definitive source for eDiscovery case law out there. One more thing, July marks five years since we started the webinar back in July 2020. So that's 5 full years, which means this webinar starts year 6. And we've covered a whopping, I know, right? And we've covered a whopping 333 unique case law rulings over that time. We're not counting repeats, just unique case law rulings. You could say we got a FIVA, and the only prescription is more eDiscovery case law, because nobody discusses more eDiscovery case law rulings than we do. And I will have to say that our 5 years has been a lot more fun than it was for Watkins Captain Coons here. And I'll just leave it at that. So with that said, let's get into the cases. In this first case, suggested by Judge Peck, who famously objected to boilerplate objections in Fisher v. Forrest several years ago. Here, Delaware Vice Chancellor J. Travis Laster opened his order by stating, the plaintiff served interrogatories and requests for production of documents. The defendant bobbed and weaved, relying on a host of general objections. Noting that boilerplate objections obfuscate, Vice Chancellor Laster proceeded to provide a detailed breakdown of the different types of boilerplate objections, in this case, including to the extent that objections, which are improper if they don't identify how the request fails to comply with rules or provide information about what will be produced. Vice Chancellor Laster overruled SLWM's objection to the request to the extent they seek to impose objections on SLWM greater than or different from those established by the applicable Chancery Court rules, finding it obfuscatory. Vagueness and ambiguity objections, because responding parties must specifically object to what is vague or ambiguous and explain how the responding party will interpret the request to make a good faith effort to respond. SLWM's objections to the status of the account were overruled as the phrase had a clear meaning and context. Relevance objections, where a general objection of not relevant is not enough. Rights requested materials such as related to his resignation, performance, customer communications, and account status were found to be obviously relevant to his claims, meaning SLWM's generalized relevance objections were overruled. And of course, the burden, overbreadth, and proportionality objections, where I've shown a few of Vice Chancellor Laster's observations here, including that SLWM's initial objections were rote boilerplate, and that Sedona Principle 6 dictates that it is not the requesting party's job to identify custodians or proposed search terms. Vice Chancellor Laster also noted that, by separate order, the court will appoint Tara Emery, an experienced discovery professional, as a discovery facilitator to help the parties design and implement a reasonable discovery protocol. And he awarded fees and expenses to the plaintiff as well. So Tom, we continue to see cases with boilerplate objections almost a full decade after the 2015 rules changes. So what do you think it will take for lawyers to stop doing it? And which will we see end first, boilerplate objections or case filings with AI hallucinations?
Well, I think the entire issue of boilerplate objections is governed by Newton's first law of motion, which states that a body in motion will continue in motion until met by an opposite or more powerful force. So that's commonly referred to as inertia. I tend to say in the legal world it's laziness, but inertia, laziness, potato. As you pointed out, people have been doing the rules changed in 2015, and we're still seeing boilerplate objections. It just doesn't change until they're met by an equal or more powerful force, which tends to be a judge who says, "Hey, what are you talking about?" As is the case here, But this is nothing new, as Judge Peck can attest. We've been seeing these over and over and over again, and they just don't seem to go away, because I guess it's easy to just grab the old motion, put in your current party's names, and file them without giving it any thought. I think boilerplate will not change before hallucinations, because hallucinations can be dealt with by a couple of other means. Software companies can build in guardrails to make hallucinations less likely. Internal IT departments and vendors, either alone or in collaboration, can do the same thing when constructing AI prompts. So I think there's much more room to maneuver and to handle quickly in an agile manner the problem of hallucinations, and that will tend to wither away far before boilerplate objections. I'm sorry.
Okay. All right. Well, I'll be interested to see if that happens, because certainly we're seeing a lot of both these days, even as judges sanction on the AI hallucinations side and waive boilerplate objections. We still see plenty, but it will be interesting.
Yep.
So Judge Peck, given that the, quote, defendant bobbed and weaved relying on a host of general objections, what can appointment of a special master do to help the situation?
First of all, it means that the party will know somebody is really watching them and knows what's going on. So, just in the facilitator, aspect, it can help parties cut through the boilerplate, cut through the inability for them to really talk to each other. Why are you objecting, other than to obfuscate? And how do we narrow the request to get a real answer, etc. Also, most people appointed as special master, special facilitator, whatever, know the case law, know what courts in that jurisdiction and other jurisdictions are, dealing with the same issue and how they are ruling. And assuming that the master or facilitator is given the appropriate authority, if you can't get the parties to, come to drink the water on their own, you force them to it. It's helpful to get the parties to resolve their discovery disputes with a little help. But if not, the special master can issue a ruling subject to appeal, or whatever it's called in the jurisdiction, to the presiding judge, and just get this over with and moved on in such a way that the parties can actually get discovery done and get to the merits of the case. And by the way, I vote with Tom that hallucinations will end before the use of boilerplate, unfortunately.
All right. Well, it'll be interesting to see if that happens. And obviously we've covered several cases that involve special master, decisions and rulings. So certainly we've seen that happen for sure. So, Mary, what advice do you have for our audience to ensure that their objections conform to Rule 34B's requirement for specificity?
Well, first I want to add my shout out to Tara Emery as a discovery facilitator. And I think this case really, gets to the heart of the boilerplate objections and gives some good examples of how to be more specific. But before we get there, I think the mindset that needs to change is that whole any and all kind of contract language. They mention to the extent that, and then invoke a broad category like requests contain implicit or explicit characterizations of discovery materials. So shifting from trying to cover every contingency to being very specific, that is a mindset change. And then they gave an example of what would be an objection that would pass muster, where they said copies of all monthly commission statements for plaintiffs and customers serviced by plaintiffs from a particular date. And the company said that was vague and confusing, and explained because customers do not receive commission statements. So they actually used words other than just like the general confusing category. The other piece is make those specific objections before the motion to compel. I'd say that's the other thing to do.
Yeah, absolutely. Yeah, and I definitely remember a case I covered a few years ago. Oh, go ahead, Judge Peck.
I was just going to say that for our audience, there are two primers from the Sedona conference, one on appropriate discovery responses and the other on appropriate discovery requests, that have a lot of helpful information. And really, as Mary was saying, it's the, because, not just saying something is overbroad or whatever, but throwing in the because and the explanation that will turn an overbroad boilerplate objection into something meaningful.
Yeah, absolutely. Which was the case I was going to mention, did that a few years ago, where they talked about the specific costs of, I think they were looking for data on backup tapes or whatnot, and they actually came up with a cost estimate to support their burden argument, which was specific, and those are the types of things that courts certainly pay attention to. So an interesting case and a great example of the different types of boilerplate objections. And we'll move on to the next case. A couple of months ago, Judge Peck informed us that one of our favorite judges to cover, Illinois Magistrate Judge Jeffrey Cole, is retiring from the bench. But thankfully, Judge Peck found one more case of his for us to cover before he retires. Here, Judge Cole began his ruling by stating the discovery dispute filings in this case are ongoing, and unfortunately, it would appear that many more are in the offing, as we are told that subpoenas are about to be issued to some 24 non-parties. At this point, production by all of those non-parties is stalled or will likely be stalled by the failure thus far of the parties and non-parties to have reached an agreement for modification of the confidentiality order plaintiffs and defendants agreed to 2 years ago in March 2023. Given that obstacle, the plaintiffs, defendant T-Mobile, and non-parties met and conferred and nearly reached agreement for amending the confidentiality order on all but 2 topics. Perhaps the most significant one being restrictions against T-Mobile's in-house counsel reviewing highly confidential information from the non-parties, several of whom happen to be competitors of theirs. While the parties, non-parties, and numerous attorneys no doubt worked diligently to arrive at a consensus, the point they reached regarding this most important topic strikes one as a starting point for negotiations rather than an endpoint where they have all drawn lines in the sand. Judge Cole pointed out issues from different perspectives, noting that T-Mobile is looking at this as the ordinary circumstance where discovery is coming from an opponent. It is not. There were always going to be problems with the confidentiality agreement that parties to a litigation came up with without any input from those non-parties from whom extensive discovery is to be sought. Not surprisingly, the non-parties who had no say at all in the formation of the confidentiality agreement did not agree to be bound by it. But he also noted the non-parties have to realize that placing restraints on T-Mobile that their opponent need not deal with is an issue, and stated, overall, the lawyers here can do better than has thus far been accomplished. Stating everyone should take a critical look at their current positions and make another attempt to come up with something workable, Judge Cole ruled, while advocating for consideration of employing a special master, the parties should, with the foregoing considerations and weaknesses in their positions in mind, meet and confer over these issues, attempt to reach an agreement, and report back to the court in 30 days. As for the briefing format for eventual motions to compel discovery from non-parties that T-Mobile and the plaintiff have been incapable of agreeing to, the court agrees with the plaintiff that as the parties have been able to resolve such a routine matter, and the court will have to impose its preference, that preference is best left for the magistrate judge who will be inheriting this case. So Judge Peck, as you mentioned, Judge Cole is retiring from the bench, and he mentioned that in referencing the magistrate judge who will be inheriting this case. So what did you do, if anything, to turn your cases over to the next magistrate judge when you retired from the bench?
Well, I finished as many cases as I could via opinions or orders, particularly non-substantive in the sense of, yes, there were summary judgment motions, but there were also motions over confidentiality orders or other things that are perhaps easier to quickly resolve. So I tried to resolve as much as I could. I also provided summaries of the history and status of the cases in front of me and gave that to my successor, who also inherited my secretary and my chambers. So at least the secretary's knowledge of my caseload made that easier for my successor to deal with. And finally, having run historically a rocket docket, I had fewer cases on my docket to turn over than a lot of my colleagues would have.
Interesting. All right. Well, very good. I was curious how that process works. So thanks for the discussion of that. So, Mary, Judge Cole noted the issue of sharing competitor information with T-Mobile, but also noted that placing restraints on T-Mobile that their opponent need not deal with is an issue as well. So how do you strike a balance to support both?
Well, yeah, you do have to recognize the difference between parties and non-parties and the sensitivity of IP-related and trade secret and competitive information and the evidence mix types of cases. Something that I've seen is outside counsel. because just as the judge at T-Mobile has at its disposal a large team of talented outside counsel from across the country who are no doubt well experienced in antitrust litigation. So you put a little layer in between the actual in-house counsel for competing aspects, and then add some sweeteners like perhaps reimbursing costs or something like that.
Yep, that's a great approach. So, Tom, what advice do you have for our audience to handle negotiations for a complicated issue like this involving both parties and non-parties?
Well, I think, first of all, Judge Cole hit it on the head. You got to get the non-parties involved in the discussions, especially since he noted that a non-party is entitled to greater protection in the discovery process than parties in the litigation. You know, I think his quote was, "There's always going to be problems with the confidentiality agreement that parties come up with without any input from the non-parties." In this case, the confidentiality agreement was signed in 2023, so you had 2 years of problems. So that's the first thing. You got to get the parties involved. I know that's difficult. I've been involved in 2 such cases, and in both cases, there were only 2 non-parties. This case, I think there were 24 non-parties, so that's difficult. I think the other thing is, don't wait this long. If the agreement was signed in 2023, don't wait 2 years to get back in front of the court and ask for help. And then, the judge himself said, let's consider a special master, some sort of an appointment to get somebody to get things moving. One of the cases I was involved in, it was interesting because it was a technical issue, not like this, which is really a confidentiality issue. There was a really deep-seated bickering about a technical issue which could not be resolved in the court. Basically, that was Judge Susie Morgan, federal court here in New Orleans. I was the technical consultant on the plaintiff side with the Southern Poverty Law Center and the EEOC, and Chuck Kellner was the consultant on the defense side. The judge, in exasperation one day, looked around the room and kind of fixated on the 2 of us hiding in the back of the courtroom together and said, "All right, I'm giving it to you 2 guys. You 2 guys come up with a solution. I'll give you, I forget what she said, a week or 10 days. Come back to me with something that you think would make this work." And so she kind of put us on the schneid. But the idea is to get a third party, whether it's the technical consultants, sort of an offset of Judge Peck's old "Bring Your Geek to Court" day, right? She ordered the geeks to get together and come up with something, and or get a special master. But don't wait this long. Don't let things drag out this long.
Yeah, absolutely. No, great advice, and an interesting case. And who knows? Maybe we still will see one more case with Judge Cole before he signs out. We'll find out. All right. Here's our next case, which concerned a hot start incident of a 1996 Beech 1900D aircraft and a dispute over how it happened, involving unique forms of VSI. VSE requested spoliation sanctions against Skyjet for failing to preserve the aircraft's cockpit voice recorder readouts. Why? Well, in August 2023, VSE requested any recording of the 2 starts that are the subject of the complaint. Skyjet responded, none known. But in late November 2023, VSE's counsel discovered logbook entries stating the FDR and CVR were reinstalled in 2022 after readout, suggesting recordings had existed. Skyjet's counsel then stated his client told him the data no longer existed. The day before discovery closed, Skyjet's president testified, which was the first time VSE learned the FDR and CVR data had been sent to Logic Air for readouts. Skyjet's president claimed Skyjet never received the readouts back from Logic Air, and that no one in maintenance had a copy. But Kansas Magistrate Judge Angel Mitchell found his testimony conflicts with all other evidence in the record. Ultimately, that evidence included critical emails produced by Logic Air between Skyjet and Logic Air, where Logic Air's production manager, email confirmation that the downloads are done and recorded on 2 DVDs. They will be in the box with the units. The CVR channels can be listened to with a PC. The one you want to listen to is channel 4. This is the area mic. It's more interesting from the 30-minute mark. Skyjet never produced those emails. Skyjet's conduct, including the untruthful and unknown discovery response, the evasive and dishonest 30b6 testimony, the fact that it was Logic Air, not Skyjet, that ultimately produced the emails, and the lack of any early initiative by Skyjet to obtain its own discovery from Logic Air, led Judge Mitchell to conclude that Skyjet's actions were beyond the result of mere negligence and demonstrated intent to deprive VSE of the CVR data in this litigation. Sanctions were harsh. An adverse inference jury instruction that Skyjet had a duty to preserve CVR data, failed to take reasonable steps, and the data was lost, barring Skyjet pilots involved in the hot start incident from testifying at trial, which was deemed necessary to even the playing field and address the prejudice to VSE, and reasonable attorney's fees and expenses incurred in discovering the CVR readouts and in connection with the spoliation motion. Judge Mitchell declined to dismiss the case, but it may have been dealt a death blow of sorts anyway. So, Mary, if Skyjet had not engaged in a pattern of obfuscation and dishonesty and simply said they can't find the recordings, do you think they would have avoided Judge Mitchell's ruling that they acted with intent to deprive?
It's entirely possible, but yeah, the way they went about it, I think they just gave the judge a good hook to for these kinds of sanctions. It's never good for the smoking gun to be produced by somebody who's not the party and not have you produce it yourself. And but it's so difficult to get these kind of sanctions. They might have been able to skirt around, but not with the pattern of misbehavior. That's the 1.1 rule, I believe.
Yes, well, yeah, it's certainly Rule 1.1, and also, sometimes the cover-up is worse than the crime, right? So that certainly falls into play as well. And so, Tom, part of the issue for Skyjet was the quote-unquote evasive and dishonest 30b6 testimony. So what recommendations do you have for our audience on how to approach a difficult 30b6 deposition involving maybe your own party's discovery shortcomings?
Well, if it's your own party, of course, we get trouble in River City, right?
Right.
I think from that perspective, some more detailed discussions with your client before they even got there would have been appropriate. I think from the other side's point of view, if you think you've got some, I don't want to say they were lying outright, but the court will come to that conclusion at some point. But if there's somebody's being at the very least disingenuous, you follow the discovery trail. I thought this was a great example of after the VSE request for production that they followed everything down. So August of 23 request for production, they're told there's nothing, right? Then they start looking through everything that they were given, and in November they find there's logbook entries that show there appeared to be some reinstalled. So go ahead and mark up a deposition. They mark up the deposition of the president, who says, "Well, we gave this stuff to a company called Logic Air." Great, then let's go find out from Logic Air. Little speed bump there because, of course, they were in Canada. They had to jump through a lot of procedural hoops to get that subpoena honored. To take a deposition, but June of 24, not a terribly long time given that sort of a hurdle. So you're talking within 6 months, they're taking the deposition of people at Logic Air, and they find out that there were emails that went back and forth and specifically discussed these, and Logic Air said we sent everything back. And the key, of course, being that Skyjet never produced those emails. The VSE got them from Logic Air. So a great use to me of following the discovery trail and just nailing things down in a relatively quick period of time there, right? The first request for production in August of 23, deposition that led to the smoking guns in June of 24. Really nice job. Better discussion between the VSE, the Skyjet people and their attorneys. I would imagine this caught their attorney by surprise.
Oh, sure. I'm sure it did. And yeah, there's a lot more detail. Tom's alluded to some of it. That's beyond what the slide can show here. This was a pretty lengthy discussion. Yeah. And Judge Mitchell did a great job of walking through the whole steps of everything and what have you. So very interesting case to read. So. So Judge Peck, with the adverse inference instruction and preclusion of pilot testimony, it seems as though Skyjet's case has crashed and burned. Yes, I said that. Do you think that's why Judge Mitchell chose not to dismiss the case? And do you think she would have if this type of behavior came from the defendant?
I mean, I don't think it would really make much difference whether it's plaintiff or defendant. You know, the question here is obviously there was a fire in the engine, or whatever a hot start means. I'm not a pilot type person, and that had to be somebody's fault. This was information that would have led to knowing why this happened. But it's different perhaps than an employment discrimination case where the plaintiff is inventing evidence, as we saw in Rossback against Montefiore, or the defendant is destroying evidence, etc. So an adverse inference and preventing the pilots, if they were ever found, from testifying is a pretty big, damage to, crash and burn of the plaintiff's case. Probably the case will not get to trial and there will be a settlement. But, it's tough to actually throw out a case that may have some justification because of discovery misconduct like occurred here.
Sure. Yeah, understandable. Great questions from our friend Sheila Grilla. Any suggestions regarding handling difficult clients who might be hiding discovery is tricky? How can an attorney come clean, or is the only choice withdrawing from the case? Any suggestions? Thoughts on that?
I mean, withdrawal is always an option and should not be, disregarded. Threatening to withdraw might get the client to realize the significance of this, and just explaining to the client how they are hurting their own case more than they are hurting the other side. Those are all things, but it is tough when you have a client who says, don't worry, I'll take care of it, or, whatever other failure to give the lawyer appropriate information is going on.
Yeah, I've got a funny anecdote about that. As Judge Peck notes, it's often difficult to do. I was involved in a case where we were trying to do a forensics examination of a hard drive, and the client was balking. I was called in to try to help them by the client's attorney, saying, he said, I think something's going on, but I'm not sure what it is here, and he won't let us get at the hard drive, but it's been ordered. And so I went and talked to the client and said, look, we'll sit there with you and you can eyeball it. Long story short, I found out quite a while later, several years later, that the client was in fact not revealing something, but what he was not revealing, we of course all thought it was something nefarious, an affair, some hidden funds, pornography, whatever. What he in fact was hiding was a whole second set of books. He was cooking the books, and he was just in a really bad place, but didn't want to admit that to us. Didn't want to admit that to anyone. I found out this fact was disclosed later after the case had been settled, everything had been handled. The guy had been was no longer with the company, shall we say, and it was as the judge said, it's often difficult to have that sort of a discussion with the client if they are in fact doing something nefarious.
Yeah, absolutely. We have seen some cases where parties have done nefarious things, and the court and the ruling record reflects that their attorneys withdrew, or that they had trouble keeping attorneys, or what have you. So certainly does happen. And great question, Sheila. Thanks. On to our next case, which was a patent infringement lawsuit suggested by Judge Peck, where Apple moved to compel Haptic to produce all documents related to litigation funding, including communications and agreements with the funder and other potential funders. Haptic and the funder jointly sought to quash Apple's subpoena in federal court in the Southern District of Texas, but Apple moved to transfer the motion to quash to this court, which was granted. The core issues addressed in the ruling were relevance of litigation funding documents, where documents reflecting Haptic's counsel's and non-testifying experts' damages analyses or royalty-based calculations shared with the funder were deemed relevant as they directly informed potential damages calculations, specifically a reasonable royalty under 35 U.S.C. sub 284, and relate to Georgia-specific factors 14 and 15, which are discussed in the case. However, California District Judge Jacqueline Corley found that Apple failed to demonstrate that 4 other categories of documents, including NDAs and communications regarding them, were relevant. The second issue was work product privilege, where Judge Corley ruled Haptic makes a prima facie showing that, absent waiver, the documents on its privilege log are protected as attorney work product. Haptic's log provides adequate explanations for what each withheld document contains, who created it, who sent it, who received it, and the date of sending. Haptic further provides a supporting declaration from its CEO, who attests that Haptic's attorneys or their agents prepared these documents in anticipation of litigation. That left the third issue, waiver of privilege. Considering the common interest doctrine waiver, Judge Corley ruled the common interest doctrine does not apply to Haptic's disclosure to the funders. Because Haptic never reached an agreement with the potential funders, no common legal interest existed between them and Haptic, even post-disclosure. However, regarding the disclosure waiver, Judge Corley ruled Haptic has not disclosed attorney work product to an adversary in litigation, nor has it substantially increased the opportunities for potential adversaries to obtain the information. Though Haptic ultimately did not enter into a final funding agreement with potential funders, they were not Haptic's adversaries, and disclosure to them did not increase the opportunity for potential adversaries to obtain the work product. So Judge Corley ruled Haptic's log documents are protected from production by the work product privilege, and the privilege was not waived by disclosure, as the funder and potential funders are not Haptic's adversaries, and Haptic's disclosure has not substantially increased the opportunities for potential adversaries to obtain the information. Tom, this is the first case I can recall that we've covered that involved actions of a third-party litigation funder. How common is it for parties to use third-party litigation funders to help them litigate the case?
Very common. It's become more and more common. It's been around outside the U.S. in other countries for a number of years. It kind of took off here about 14 or 15 years ago. Current estimates are that there are between $2.3 and $5 billion being fronted annually by funders in litigation in the United States, mostly in high stakes areas, big class action, MDLs, patent litigation, etc. Although there's been a growing rise in the last several years for consumer funding for personal injury and small claims cases, often under 10,000. As this case pointed out, the big problem is it's hard to know what that actual number is because of the disclosure issues that have come up, and in fact, some states and even courts have started to require disclosure. And I think really there's as Kaylee mentioned at the beginning, we posted a couple of great articles, one from the United States Chamber of Commerce on the issue, another one's from Mark Behrens, who's at Shook Hardy and Bacon, and he's chairman of their, or co-chair of their public policy group. Two great articles that go into both of those issues a lot deeper. There's also a third one I'd forgotten about, but I posted it on LinkedIn just by coincidence a little while ago. The Redgrave firm has an article on their website that deals with these sorts of companies, this sort of funding and the issues. So some great resources that'll really dive a lot deeper into it.
Yes, and go ahead, Judge.
I was just going to add that Lawyers for Civil Justice and others have proposed, and the Federal Rules Committee is considering, whether there should be rule changes to the Rules of Civil Procedure with respect to litigation funding and what needs to be disclosed, et cetera.
Great. Yeah, it's a hot topic. Absolutely.
Yeah, and thanks for finding those resources and providing them to our audience, Tom. Definitely very helpful. So Judge Peck, Judge Corley stated that disclosure of work product to a third party doesn't waive the protection unless it's made to an adversary in litigation or has substantially increased the opportunities for potential adversaries to obtain the information. I thought disclosure of work product to third parties generally constituted a waiver. Where do you draw the line?
You know, I have the feeling here that the line got blurred by Judge Corley because he's right. The common interest doctrine technically did not apply here. Nevertheless, it doesn't seem fair that the other side would get this information just because it was shared with a litigation funder. So I think this was perhaps very much line blurring to reach the just result. You know, I can't say I've ever seen this issue come up before in other contexts, because usually the waiver of work product would come up in the, you know, you didn't have a 502D non-waiver order, you produced some work product documents to your adversary, and then you tried to claw them back, you know, that sort of situation. I would not have said I knew where the line was here prior to reading this decision.
Yeah, interesting. And it was an interesting case you suggested there. So Mary, Judge Corley cited haptics privilege log as being key to the determination that documents were privileged. What advice do you have for our audience to ensure their privilege log can support situations like this?
Well, first I would go way before the privilege log and go to privilege training. You know, certainly when you're seeking services or financing litigation funding, but I could see it as organizations are seeking eDiscovery services as well. Being very careful what gets communicated and documented, and that privilege training occurs. And there are resources available both from Sedona and also EDRM's privilege log project has it, which is available on the EDRM website under the project page, has some examples of what logs could look like. And how important it is to have court consumable documentation with like the bare facts, not be all commingled with mental impression, strategy, and that type of thing.
Yeah, great tips and great points. So we'll move on to our next case. And it's time for another case involving hyperlink files, which I'll be a part of a panel discussing on EDRM's and NextPoint's webinar on August 19th. Here, Defendant Crow contended he was entitled to an adverse inference instruction because of spoliation of ESI by the plaintiffs. Defendant's motion addressed two types of ESI, an unedited version of a podcast interview of plaintiff Julia Hubbard and computer data that belonged to defendant Richard Hubbard. After plaintiff Hubbard sat for the interview, the podcaster sent her a link to the recording of the podcast for her feedback. The email with the link from the podcaster was produced, but not in its native form, so the hyperlink in the document was not active. Plaintiff Hubbard forwarded an email from her attorney to the podcaster containing advice to remove a 4-minute segment that, quote, takes the heat a bit off defendant Crow if his lawyers come across this, unquote, from the podcast, and the podcaster edited the recording as requested. The parties represented that the edited version of the podcast was still publicly available, but the unedited version the podcaster originally sent was not, and plaintiff Hubbard and her attorney represented that the link in the email to the original recording did not work anymore. Neither defendant Crow nor plaintiffs took steps to ascertain whether the podcaster or anyone else still has the original version of the recording. As for the computer data before the litigation began, plaintiff Gettinghouse accessed and copied data from defendant Hubbard's computer to her own, but the data on the computer was wiped when it was unclaimed at a repair shop for too long, and the SD card to which files had been transferred had become corrupted. As Texas Magistrate Judge Alyssa Chesney stated, there are two obstacles to defendant Crow obtaining Rule 37E relief at this time, and counsel for defendant Crow conceded at the hearing that the requested relief may be premature. First, it is not clear that the requested ESI is not replaceable or restorable. The podcaster or her company may still have a copy of the original recording, and defendant's forensic specialist may be able to restore the files on the corrupted SD drive. Regarding the linked podcast file, she said, the question of whether the podcast recording was ever in plaintiff's possession, custody, and control is also in dispute. It appears that the email with the link to the recording was sent to plaintiff Hubbard, who forwarded it to her attorney during the time period covered by defendant's discovery requests, and that the email and the recording would have been responsive to those requests. Plaintiffs did produce the email, but did not produce a copy of the podcast file linked in the email. While the recording may have remained in the custody of the podcaster and merely streamed by plaintiff Hubbard and her attorney by asking the podcaster to delete a portion of it, plaintiff Hubbard arguably exercised control over the file. But for her request to cut a portion of the recording, the entire recording would be available instead of the publicly available version, which is the edited version. Plaintiffs contend that plaintiff Hubbard and her attorney did not have control over the file and were merely asking that a portion of the podcast not be aired, not that any portion of the master recording be deleted, but the email itself refers to making cuts and is not phrased in terms of what should broadcast, so plaintiff's alternative reading is not the most plausible one. To avoid the possibility of sanctions under Rule 37E, plaintiffs are directed to contact the podcaster to see whether it's possible to obtain the original version of the file. Wow. So, Judge Peck, since the podcaster is a non-party here, do you agree with Judge Chesney's ruling to have plaintiff request the unedited podcast? Shouldn't the defendant do so instead via a third-party subpoena?
You know, we've seen this come up in several cases of, in order for 37E sanctions to apply, the original material must not be available anymore. So whose burden should it be to get that information to rebut the loss factor? I have the feeling that the judge suggested or ruled that the plaintiff should try to get this from the podcaster because it appears from reading the case that there was a relationship with the podcaster and the plaintiff that made it more likely that the podcaster would cooperate with the plaintiff. Nothing would stop the defendant from also issuing a non-party, third-party subpoena here, either when plaintiff didn't move quickly enough or when the podcaster didn't voluntarily provide it to the plaintiff. But I do think the judge was saying implicitly the podcaster is likely to cooperate with the party whose interview is at issue here.
Yeah, that does seem to make sense. So Mary, do you agree with Judge Chesney that plaintiff Hubbard exercised control over the file simply by asking the podcaster to delete a portion of it?
Well, it's the request was made and it was complied with, and my sense is that they did have some control there, influence for sure, but possibly control as well.
Yeah. Well, so Judge Chesney seems to imply that plaintiffs could receive sanctions under Rule 37E if the podcaster doesn't have the original version of the file. Does that seem fair?
Well, if it was taken in the abstract and it was just two independent parties, perhaps not. But I agree with Judge Peck. In reading the case, it seems like there was a relationship there. And that's bolstered by the fact that there were requests from the plaintiff and the attorney to cut the recording. So I think that overrides any sense of independence or working at hand's length here. So yeah, I think it is fair. I think it's equitable. I'm not fair.
The other thing I'd add is, it's a question of making up for the lost material, the material that the plaintiff had access to through the link,
Right.
and
Right.
therefore could have produced the unedited version, but either the link died or the plaintiff, didn't do what was necessary to provide the hyperlinked material. So, yeah, I don't see a problem with blaming the plaintiff if the supposed non-party, independent, whatever, didn't have the material to get her out of hot water here.
Yeah. Okay, interesting. Because I could certainly see, and I think we've covered other cases where if a hyperlink file is in basically the possession of another party, I could see why they could say, well, we don't have that file. You'd have to get it from this person. So I don't know. It's going to be definitely, I think we're going to see more instances of arguments over possession, custody, control of hyperlinked files. And I thought this was a good case that illustrated what those issues might look like. And we would talk about it more, but we have 3 minutes to cover our last case. So we got to move on. And our last case gives us our first Yogi Berraism in a while. It's never over till it's over. In the case in September 2021, defendant Tracy Ogle reported that his laptop hard drive malfunctioned due to BitLocker encryption, making it inaccessible. He claimed to have taken it to Best Buy for service and later replaced the drive at the end of the month, disposing of the original. Ogle disposed of the hard drive soon after the alleged malfunction, and a new hard drive was installed around November of 2021, but plaintiff didn't receive notice until almost a year later. In a ruling we covered earlier this year, Nebraska Magistrate Judge Ryan Carson granted in part and denied in part plaintiff's motion for sanctions, finding that there was likely relevant information on the laptop and Ogle had an affirmative duty to preserve it, but he did not find bad faith on the part of Ogle and instead ordered reimbursement of attorney's fees and costs as the only sanction. Plaintiff objected. Considering plaintiff's objections that monetary sanctions weren't sufficient, Nebraska District Judge Robert Rossiter stated, those objections are generally well taken. Based on the evidence presented, the magistrate judge found that the destroyed ESI contained information that was likely relevant to this litigation. The payments of fees and costs do nothing to address the high probability that Ogle's actions deprive Clayton International of information that could support its claims. The court agrees with the magistrate judge that Ogle's actions caused Clayton International to expend additional time and effort investigating and litigating the issue, for which monetary sanctions are appropriate. It disagrees, however, with this conclusion that the harm caused to the Clayton International may only be cured with monetary sanctions. The court will therefore permit the parties to present evidence regarding the destruction of Ogle's hard drive at trial. Interestingly, though, he also said this. Clayton International requests their instruction be given pursuant to Rule 37E2 and objects to the magistrate judge's ruling that sanctions are not warranted under that subsection in this case. That confuses the issue. As far as spoliation-related instructions go, a bad faith finding under Rule 37E2 is only required where the court instructs the jury that they may or must presume that the lost ESI was unfavorable to the spoliating party. Though not without teeth, the instruction Clayton International requests does not go that far. because that instruction essentially informs the jury only that it may consider spoliation evidence along with all the other evidence in the case in making its decision. It too is warranted under Rule 37E1 to address the evidentiary prejudice resulting from Ogle's actions and assist the jury in assessing evidence presented at trial. Since the court will only later determine the precise scope of the spoliation evidence to be permitted at trial, it will wait until that time to craft the specific language of the jury instruction on a full evidentiary record. So, Mary, do you think Clayton International blew their chance at Rule 37E2 sanctions by how they worded the proposed instruction to the jury?
Entirely possible, but I believe it could have been a strategic decision to bank a win, or it could be a mistake, and I'll leave it at that.
Okay, fair enough. So, Tom, given that Ogle repeatedly provided false statements under oath regarding the circumstances surrounding the destruction of his laptop hard drive, are you surprised that neither judge found intent to deprive?
Well, I thought what I was reading was that the court ruled that the jury instruction, the proposed jury instruction, didn't have the necessary language to get there, and that without that, they were going to wait until later to determine what the scope of the spoliation evidence was, and so I didn't think they were shutting the door on it. I just thought they were saying it's a little too early giving the proposed instruction.
Okay, all right. Well, so Judge Peck, it seems as though judges are highly reluctant to issue Rule 37E2 sanctions unless absolutely necessary. Is it appropriate for a judge to do so if they find bad faith, even if the requesting party didn't request a strong enough instruction?
You know, we've talked about Rule 1.1, but let's actually go to the written rule, Rule 1. And in essence, the court is supposed to do justice. So if the court is going to do something that wasn't requested by a party or wasn't requested directly by a party, I think it is incumbent on the judge to give notice to all counsel and an opportunity to argue the issue. But I think a judge can and should do justice where necessary, even if a party, whether it's the party's fault, their lawyer's fault, strategy that wasn't optimal, perhaps, whatever it may be, the court should be able to do the right thing. And I think that's what was going on here.
Yeah, absolutely. All right. Well, that may be one of the fastest coverages of a case we've ever done, but managed only to come in 2 minutes past. So onto the contacts page, and we have a date for our next webinar, which is zoinks, only 20 days away. And as the picture of the Bengals indicates, it's on another Manic Monday, August 25th. We won't walk like an Egyptian for it, though, because we'll be sitting down. So with that, I will say thanks to Mary, Tom, and Judge Peck for their terrific insights as always, and I'll turn it back over to you, Mary.
Thanks, Doug. We thank you for anchoring, Tom O'Connor and the Honorable Judge Peck for this wonderful presentation. Our thanks to the EDRM community for your kind attention. If you really loved it, show Honorable Judge Andrew Peck, Tom O, and Doug Austin from Houston some love. Find your emojis at the bottom of your console. And to be automatically registered for on-demand webinars, click the pop-up at the conclusion. Once there, click the bell to subscribe for updates. And we'll see you next time on the EDRM Global Webinar channel. Thank you.
Bye, everybody.
Bye, all.